Hey, 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 it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hey, y'all. So, into this Tony Buzbee Jay-Z saga, I did promise that I was going to update you guys in regards to the lawsuits that were filed against Tony Buzbee and the Buzbee Law Firm. As of right now, there are just two cases out of Louisiana in federal court that are against Tony Buzbee. The New York case where the woman, Claudia Brady, had stated that he gave her a venereal disease and all the other stuff, that has since then been dismissed. But in the midst of that, they ended up filing a grievance against Tony Buzbee, and that's why Tony Buzbee is in that in that whole having to do the Pro Hawk Vice uh route. But going back to the other two cases that are against him. So these two cases are very, very unique. These cases were actually filed days after he amended the complaint to add Jay-Z to the Jane Doe lawsuit against Diddy. That's number one. As I said it before, Claudia Brady's case was dismissed because she did not read her contract. If y'all notice with these lawsuits against him, they're saying he either misappropriated funds or they got an amount that they wasn't satisfied with, the whole nine yards. Let me tell y'all something. Let me tell y'all something. One thing I make sure, and every personal injury firm does this. When we collect the settlement, it's a process. When we settle, the first thing the client is going to see is the settlement agreement from whoever is paying out, whether that is the insurance company or an entity, whatever the case may be. That is the first thing that they're going to see. The second thing that they're going to see is a settlement statement or a settlement memo. On that, it will have the breakdown. It will show how much the settlement was, the attorney's fees, the cost of obtaining medical records, billing records, whatever expenses that we had to pay for in order to move your case along. Any advances that you got, whether it's from the attorney trust fund or from a company like Oasis, companies that actually give you a loan until your settlement comes, minus any medical bills that are outstanding after we have negotiated a lower bill. Then any subrogation liens for if you had your insurance, your private health insurance cover anything. Minus, but on top of all those minuses, if you got child support, that's coming out. And then at the very bottom, you will see what is called your net to client, how much you will be getting. I have never worked for a PI firm where a client has never received a settlement statement to show their breakdown. And they have to sign that. So they're going to sign the settlement release from the insurance company or whoever's paying out that settlement. They're going to sign the settlement statement or memo that breaks down what they're going to get. And then last but not least, your payment information. Are we going to wire it? Are we going to send you a check? Are you going to come pick up your check? Whatever the case may be. Case closed. We send out a closing letter. In our closing letter, we reiterate everything as far as what is taken out, what you're going to get. We encourage people to go on to AVO or Google to give a review. With that being said, listen to what these individuals are claiming Tony Buzbee did. Now, mind you, once again, this is after Tony Buzbee has amended the complaint to add Jay-Z as a defendant. One of these cases in Louisiana was filed December 13th. The biggest thing here, and I'm telling this for anybody, if you get hurt in any way, shape, form, or fashion, and you reach out to a personal injury firm, you're going to go through intake. If we accept your case, you're going to sign a contract. I'm telling y'all this right now. Read your contract. It tells you everything that you would need to know. The fees, if we settle your case before it goes to litigation. The fees if we have to go to litigation. Also, the fees if we have to appeal after the litigation. It talks about cost. It talks about mediation if you don't like something. All of this is in the contract. But yet, Claudia Brady and these two individuals uh, uh, from Louisiana obviously did not read their contract, and it's obvious. So I was thinking, hey, Cassandra, how can you get a copy of the attorney client agreement that Buzbee has? And then I was like, aha, he actually submitted it as an exhibit in the Claudia Brady case. And that's what we're going to take a look at. I'm going to go over his attorney client agreement. I'm going to read a portion of the complaint that was filed against him by the two people in Louisiana, pretty much the same. And then I'm going to read the motion for sanctions that he submitted, Buzbee submitted, because he's like, this is frivolous. The same thing I'm telling y'all, this is what Buzbee is explaining in his motion for sanctions. How do we get here? It is not my fault that the client decided to sign and walk away. You waited so many years to say, "Oh, now I'm not happy with what I got. Oh, now I believe I should have got more than what I received." But let's hop right on into this good old attorney-client agreement because it's here, and it's actually standard. Actually, I pulled up the. Let me pull up the. There we go. Wrong one. Here we go. Attorney-client agreement. Now, this is the power of attorney and contract of employment, also known as the attorney-client agreement. I know since then he has probably changed this, but it's pretty much standard language. We tell you exactly what it is that we're going to do. We tell you what our attorney fees are. Here, and this is Claudia Brady's, 40% interest on any recovery on the claim, or 45% interest on any recovery on the claim if notice of appeal is filed by any party to the litigation. We work on contingency fees. Now, for our firm, it's 35%. 40% if we have to go to litigation, 45% if we have to appeal. Some firms do 33 and a third. And if you possibly is family or a good friend of the firm and you want us to take your case, the lowest any attorney is going to do is 30%. It's here. It simply tells you as compensation for the services to be provided by attorneys in the prosecution of this claim, client agrees to pay attorneys the following contingency fee interest to be deducted first from the gross sum recovered on the claim. So, like I said, standard is either 33 and a third or 35%. In litigation, 40%. And if we have to appeal, it's going to be 45%. How are they calculated? Client understands and agrees that this contingency fee shall be calculated based on the gross recovery, if any, on the claim. In other words, the attorney's fees is calculated off the top of the gross recovery. After attorney fees have been deducted from the gross recovery, then any case advances, litigation expenses, and interest shall be deducted from the remainder. And then the client will receive the remaining balance. Client understands that by entering into this contract, that client is assigning a current interest in client's claims to attorneys. It can't get no clearer than that. And you know what? I'm gonna pull up ours. I'm gonna pull up one of our whatchamacallit so y'all can actually see. It's similar. But what happens is clients don't read the contract. All they do is, okay, I initial here, 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 and I sign. After I do an intake and I said I'm sending you the intake packet, what I tell them is please read the client attorney agreement in its entirety. So many people have come back. Well, I didn't know it was start. Well, did you read? Oh no, I just signed. I was like, well, it says it in the contract. The parties and particularly client understand that the client has the right and ability to retain counsel, whether it be attorneys or any other attorney, on an hourly basis for this claim. If so, client would be obligated to pay such attorneys for the hourly rate of such work. Client have would have to pay all expenses, and this money would be owed regardless of the outcome. If there was an expeditious outcome, the fees and expenses were relatively low. If the outcome took years to obtain, then those fees and expenses would be significant and would be owed regardless of the outcome. Client, after considering the risks, pros, and cons as to whether to choose to retain attorneys on either a contingency or hourly basis, has elected to retain attorneys on contingency basis. So it's telling you the difference between contingency and actually paying a lawyer on an hourly basis. It's good to do contingency because we pay for, if there's medical records that we have to order and there's a cost, we pay it. If we're in litigation and we got to do depositions, or we got to hire a court reporter or a videographer, or we have to purchase depo transcript, or if we have to pay for mediation, we pay for it out of pocket. So everything is upfront. We front everything until you get your settlement. But if you elect to pay the attorney on an hourly basis, that means you're going to end up paying for medical records, depositions, getting the transcripts, paying to mediate, all of that. So that's the difference. That's why a lot of 100% of personal injury firms, we do it on a contingency basis. Costs and expenses. Do I want to read this? But let me tell y'all what this is. Yeah, I'm gonna read this because y'all have to understand before I get into what we're gonna get into. Client acknowledges that attorney will be advancing various court costs and expenses of litigation, including but not limited to court filings and service fees, copying costs, postage, investigation expenses, FASA expenses, court reporter and deposition fees, video and audio taping fees, messenger services, expert fees, fees associated with obtaining medical and other records, and other customary expenses incident to litigation. In cases in which attorneys represent more than one client on claims regardless of a single event, some of the expenses that benefit all of the clients may be shared on a pro rata basis as a discretion of attorneys. So pretty much if I have three plaintiffs on the case and let's say it costs $20 to get a police report, I will split that $20 amongst the three of them. So they all pay a share of, that cost. Attorneys may, but are not required to do so, also make cash advances to client if and when client is not able to work or in other circumstances and thus requires funds to maintain their household. Case advances are completely within the discretion of attorneys. Attorneys may also make payment to medical providers so that client may obtain medical treatment for the injuries associated with the claim. With that being said, you do not realize people will be like, hey, I need a loan. I'm not working. So, what do? We actually advance them some funds. And that's only if we know that, okay, we do believe that we might get some, a good settlement out of this case. But the attorney does have a right to put interest on that. And would you rather get an advance with a low interest with your attorney, or would you want to go to Oasis and have like a 200% interest and end up owing your whole settlement check to Oasis? But anywho's, client acknowledges that in the event the attorney makes any such advances from attorney funds, then attorneys are authorized to charge interest on such advances, and client specifically agrees to such interest rate. Client agrees that at attorney's sole discretion, attorneys may also charge interest on any medical bills paid by attorneys. Because there are some times where a provider may be like, okay, we need $500 up front and we got to pay that. So what Buzbee is saying is, we'll pay that $500, but we're going to add interest to that. Attorneys agreed to provide a current statement of expenses to client upon request and also at the conclusion of the claim. That's what I call the settlement memo, a settlement statement. All expenses discussed above are deemed approved to as to the reasonableness, unless client makes a written objection to the attorneys within 7 days after the receipt of a statement itemizing the expenses. If there is no objection, attorneys will provide information to support the claimed expenses. So at no time did any of these individuals submit in writing that they had an issue with what was on that settlement memo. In the event attorneys do not obtain a settlement or recovery for a client has no obligation to pay any legal fees or expenses set out in the above paragraphs. Uh-huh. Yeah. So this is a standard PI whatchamacallit. Let me see. All right, so these are the hourly rates if they decide to pay, but ain't nobody about to do that. Let me see. Arbitration. And so this pretty much says, and this is very important. This is the part where Claudia messed up at. So instead of you filing a law, instead of you doing mediation arbitration, you took it to the court. And that's why your case got dismissed, because it clearly stated in this contract right here what you are supposed to do, ma'am. And that goes for all of them. Arbitration. The following paragraph is intended to explain certain advantages and disadvantages of binding arbitration so that the client can make an informed decision as to whether to agree to enter into this agreement containing an arbitration clause. Generally, there are certain possible advantages, disadvantages, and other consideration when electing arbitration as compared to judicial court resolution of disputes. This includes the cost and time savings sometimes found in arbitration, the waiver of significant rights, including the right to a jury trial, the possible reduced level of discovery in arbitration proceedings, the relaxed application of rules of evidence in arbitration proceedings, the loss of right to judicial appeal. Because okay, so those are the goods and the bad. All right, let me just get to this part. Client agrees that any dispute whatsoever arising out of this agreement, including dispute regarding fees or the proper and reasonable rendition of legal services, will be resolved by arbitration. I'm going to read that one more time for the people in the back. Client agrees that any dispute whatsoever arising out of this agreement, including dispute regarding fees or the proper and reasonable rendition of legal services, will be resolved by arbitration. So if you had an issue with your settlement, going to court that is not, you signed a contract that stated if you had an issue with legal services or the services provided, if you had a dispute on the fees or whatever that arise out of this contract, you are supposed to go to arbitration first. The arbitration will take place in Harris County. Such arbitration will take place before three arbitrators. Client will choose one. Attorneys will choose one, and the arbitrators chosen by client and attorney will mutually choose the third arbitrator. Any court action to compel arbitration or enforce any arbitration award relating to this agreement must be initiated in Harris County. Client agrees that the arbitrator will apply Texas law to any dispute relating to this agreement. Client specifically has read, understands, and agrees to the terms laid out in this paragraph. So, Miss Claudia, she signed this. She signed this, but it's apparent that she didn't read the arbitration clause. Thus, the reason her case got thrown out or dismissed, I don't want to say thrown out, was dismissed. Now, let me take y'all to the Louisiana case. I'm not going to keep y'all here too long. So, two U.S. Guard individuals decided to sue Buzbee. And I'm just going to read one of these petitions because they're pretty much verbatim, just different people. Tony Buzbee and the Buzbee Law Firm represented Adam Gertie, a U.S. Coast Guard licensed ship captain who was severely injured on a job. The Buzbee defendants told Gertie his case was worth $100 million, but later coerced him in settling for less than one-third of that amount. In insisting that he settle, Buzbee defendants never explained Gertie's options, never discussed the pros and cons of trial versus settlement, never disclosed mounting expenses, and never disclosed the merger amount Gertie would receive as distribution. Instead, defendants told Gertie he had no choice. Gertie was vulnerable. He had lost his job as a result of his injury. He was financially destitute, his marriage had failed, and he was struggling with addiction. Relying on his lawyers, Gertie accepted. When the settlement funds were dispersed, Gertie was stunned to receive only $5,123.19. The Buzbee defendants had taken 98% of Gertie's final disbursement and 74% of his overall settlement. The Buzbee deducted $53,000 in fees and $266,876.81 in expenses, including $90,000 for expert witness fees, approximately $5,000 for postage and copies, travel expenses, more copies, closing fees, all of that. All of that. He also had a loan. Let me see. He charged 23,000 in interest on a 85 approximately $85,000 of loans. But y'all get the picture, right? Now we just read the agreement that everybody is required to sign. We cannot work on any type of case until you have until you have signed that attorney-client agreement. Sir, I'm telling you this right now. You had 85 that like these fees add up. So, despite he signed off on this $5,000, but he's claiming that he had no other choice, that Buzbee and them was pushing them. They didn't break down, all of this other stuff. I call BS. I call BS. I call BS that a firm will tell you how much your case is worth. One thing that I have learned in this field is you never tell a client how much you think they are going to get. Nothing. The only thing I tell them is however much your medical bills are, times that by 3. That's what we're going to demand, but it's no guarantee that we're going to get that demand. I always say I cannot put a number on it. The only thing I say, the only way you can maximize your personal injury case is by doing what the doctor says. Treat, until the doctor releases you. Period. This man signed a contract. This man signed the settlement statement. Well, before he even signed the settlement statement, this man signed the settlement agreement to whoever paid this settlement. Then he signed the settlement statement. So if you went back to your contract, you would have seen the clause that say if you do not agree with case expenses, if you don't agree with the fees that are taken out, you got to go to arbitration. You have to go to arbitration. That wasn't done. He went straight to the courts. This case and the other case will be dismissed. That's why Tony Buzbee saying that it's going to be dismissed. Just like the one in New York, it's going to be dismissed. Now, I want to tap in to the motion for sanctions that Buzbee filed in both of the Louisiana cases. Right quick. So, the motion that Alex Spiro was trying to file against Buzbee. Yeah, they love doing this. All right, so very, very quickly. Defendants Anthony G. Buzbee and the Buzbee Law Firm respectfully submit this memorandum in support of their Rule 11 motion for sanctions against plaintiff's attorney Timothy W. Porter of the Porter Maloff, PA, and Kelly Berry of the Berry and Munn, PA. Now, Buzbee is not representing himself. He does have an attorney that is handling this. Okay. As shown herein in violation of Rule 11b2, plaintiff's attorney knew or should have known of the existence of evidence that clearly refutes the factual allegations plaintiff makes in this complaint. The violation of Rule 11b3, plaintiff's attorney also knew or should have known that plaintiff has waived any claims or complaints he could have made regarding the settlement he freely and voluntarily agreed in a sworn writing more than a year previously. Plaintiff's attorney filed this baseless lawsuit anyway. The contract that I just showed you guys. Period. He signed a contract. There it is in writing. What else can you do? You signed a contract. That's why you have to have tangible evidence. You see where tangible evidence can get you? Further, plaintiff's attorney included in the complaint multiple immaterial, impertinent, and scandalous accusations which bear no relevance or relationship to plaintiff's claims. These allegations violate Rule 11b1 because they were included by plaintiff's attorneys for improper purpose, namely to harass the Buzbee defendants and to damage their reputations. Plaintiff attorneys should be sanctioned accordingly, including but not limited to an award of reasonable expenses, including attorney fees incurred in bringing this motion. The complaint in this matter was filed on December 13, 2024. As stated therein, plaintiff is represented by Timothy W. Porter and Kelly Berry. The complaint alleges that Buzbee defendants are a Texas attorney in his law partnership. It alleges that plaintiff was referred to the Buzbee defendants by another attorney to represent plaintiff in a personal injury suit for injuries sustained while working aboard a vessel, the General Eisenhower. These allegations are partially correct. Plaintiff executed a contract for legal services with the Hodge Law Firm on December 5th, 2019. In connection with his injuries, see Exhibit A. So, Exhibit A is his contract, his initial contract with Hodge Law Firm. And sometimes we do that. Sometimes clients will get with one firm, fire them, and get with the other firm. Now, that first firm, if they did work, they will put a lien on that settlement. If they did work, ain't nobody working for free. So if you fire us and go to somebody else, we are going to put a lien on that settlement. Point blank, period. Plaintiff agreed to a 40% contingency fee that Hodge could associate another lawyer or law firm in connection with the representation, which will not increase the total fee owed by client. Because what happens if Hodge, okay, so let's say Hodge said, okay, we're going to work with the Buzbee law firm. They're going to show, they're going to share that 40%. They're not going to take an additional 40%. They're going to split that 40%. That's how that works. So if the client got $100 million settlement and there were 20 law firms that helped, those 20 law firms is going to share that 40%. So 40% times whatever 1 million is, whatever that fee is going to be split amongst the 20 law firms. Pursuant to a consent to association of additional counsel contract executed by plaintiff explicitly agreed to the association by Hodge of the Buzbee defendants for the purpose of assisting in the prosecution of client's case. See Exhibit B. Under the consent to association, plaintiff agreed that Hodge and the Buzbee defendants would jointly represent plaintiff and that the 40% contingency fee under the legal service agreement would be split, with a 60% being paid to the Buzbee law firm and 40% being paid. So if that 40%, let's say that was 500,000. I know I'm good at math, but I'm just trying to give y'all simple numbers. Okay. So we had the $1 million. You know what? Let me stop that. Let me l- let me just do this. Oh, y'all can't see my calculator. Okay, so I have $1 million on the screen. We're gonna multiply that by, I said what, 40%? All right, so that's 400,000. So of that 400,000, 60% of that went to the Busby law firm, 40% went to Hodge, the first initial law firm. The complaint alleges that the Busby defendants coerced plaintiff to settle for less than one-third of the purported value of his claim, failed to keep him informed about expenses and other matters, and allegedly deducted inflated expenses, loans, and interest from the settlement funds. There is no explanation whatsoever how plaintiff was allegedly coerced to settle his claims. Specifically, the complaint claims Busby defendants never explained Gertie's options, never discussed the pros and cons of trial versus settlement, never disclosed mounting expenses, and never disclosed the meager amount Gertie would receive at distribution. The complaint urges that the Busby defendants failed to disclose to plaintiff the ramifications of settlement versus trial. The complaint alleges that the plaintiff was stunned when the settlement funds were dispersed because he received only, claiming the Busby defendants had taken 98% of Gertie's final disbursement and 74% of his overall settlement, which Gertie claims was grossly excessive. Clearly referring directly to the detailed statement dispersed documents provided to plaintiff by the Busby defendants, the complaint alleges. And he pretty much said the Busby law firm deducted this and that and blah, blah, blah. Based on these facts, the complaint attempts to state three causes of action: breach of fiduciary duty, unjust enrichment, and negligence. What the complaint fails to mention is that more than a year ago, on September 28, 2023, plaintiff was provided and executed a detailed settlement affidavit in advance of the settlement and disbursement, which directly contradicts the factual allegations of the complaint. What did I tell y'all? And they actually attached it. So we're going to see that once I get through reading all of this. The settlement affidavit contained a detailed breakdown of the settlement and disbursements, including the agreed 40%, which was a 60-40 between the Busby defendants and Hodge, as plaintiff had previously agreed. It also contained a detailed breakdown of all expenses deducted from the settlement. Most notably, In the settlement affidavit, Gertie certified under oath because we put that language in there. If y'all don't read, I don't know what to tell y'all. When I became a paralegal, I told myself there is no reason why I should not read these documents. And when I tell y'all I read, I read. I'll be like, give me a minute, don't rush. My house, my car, signing my kid, anything I have to put my pen to and sign, I read. I teach my kids the same thing. You do not put your name on anything without reading the terms and conditions. So, Mr. Gertie, under oath, when put his signature on that settlement statement, this is what it said. I have reviewed and understand the breakdown of the settlement funds in this case and state that the same has been explained to me by my attorneys to my satisfaction. It is also understood that all of the above listed medical bills have been paid out of my settlement funds. I have been advised that any questions regarding this disbursement will be explained to my satisfaction, and I certify that I am fully satisfied with the information I have been provided and the services rendered by the Buzbee law firm. Gertie also agreed under oath that he understood that if he requested loans from the Buzbee law firm, interest would be charged and that he knew in advance of such charge and agreed to such charge. Finally, in the last paragraph before plaintiff executed the settlement affidavit, aka the settlement statement, settlement memo, before a notary under oath, he agreed. Prior to settling this case, client understood and agreed that such statement would fully resolve his or her case and understand that if the case continued, might receive more or less, but client alone made the decision to settle to avoid further litigation and the uncertainties of the what the future holds. As stated, it is apparent that the plaintiff's attorney knew the settlement affidavit since they referred to plaintiff's execution of it in the complaint and directly quote from it. Yet plaintiff's attorneys ignored the explicit representations, acknowledgement, and agreements Gertie made in the settlement affidavit, which, without question, established that he waived any possible claim or complaints he could have regarding the settlement and disbursement of the settlement funds. Moreover, to the extent plaintiff attempts to state any tort claims under Louisiana law, plaintiff's attorney knew or should have known those claims are prescribed. I don't even have to read any further because that's just the gist of this. So, pretty much the complaint was made out of, I guess, hate. They are trying to bring Buzbee down. If y'all do not see, y'all have to look at the timeline of these filings. You have to look at the content of what these lawsuits against Buzbee is about. These clients signed a contract. Hold up. And to be matter of fact, I love when you have to go back. Oh man, you know what? I just thought about that. I don't have access to that. Got diggly muggly. But y'all seen that, y'all already seen it. Y'all already seen what the contract looks like. So what Buzbee did, Buzbee went ahead and he attached the agreement. Let me tell y'all something. What we do. And people don't even realize that we do this. We have to hold files for up to 7 years, whether it is in office or in a secured storage. Okay? So it never really goes away. So when stuff like this happens, we will be able to go back and we will be able to pull your whole case file from the intake sheet to the signed settlement statement or signed affidavit. And I'm glad that he does, and I'm gonna speak to my attorney because maybe we need to do settlement affidavits. Because with affidavits, you have to get that notarized. So I think we might need to start doing that. Because what happens is these people come back and be like, oh my gosh, this is how much that I'm getting. Okay, that's one thing, but don't come back and be like, okay, well, I feel like I should have got more than that. You already signed. You already signed. It was in your agreement when you first signed up with this with us. We had a lady, I don't even know what she's trying to do. She, before she even hired our firm, she ended up signing a settlement with one of the insurance companies. And now she's coming back, well, I didn't want to take the money, but you signed the settlement, they sent you the check, you cashed it and you spent it, but now you're coming back and say, well, I felt like I should have got more money. Did you read that settlement release that you signed saying if you sign this, that's a wrap? You can't come back and file another claim. It's you agreed. People, read your contracts. There's no reason. I don't care what type of contract it is. You need to read it. Oh darn. Yeah, I can't I want darn it. I have to go on to Pacer and see. And I don't even think that this is available on my other um site that I go to, but that's okay. That's okay. The fact of the matter is these people signed attorney client agreement, they signed a settlement release, and they signed a settlement affidavit. It clearly states what you needed to do if you felt that you were not happy with the services, with the fees, or anything that arise out of that out of that agreement, and you failed to do so. So just like the Claudia Brady case was dismissed, and the judge pretty much they said, if you still have issues, do arbitration, which has to be held in Harris County. Point blank, period. There's no other way around this but through arbitration. So just like her case was dismissed, these other two will be dismissed. I hope I have broken this down for you guys and you understand the process and you understand why this case is going to be dismissed eventually. And I'm wondering if the judge is going to grant this motion for sanctions because it's going to be because I'm questioning the attorneys like, y'all, signed, he had to sign 3 documents. And at none of those times did you ever question anything. That's the biggest thing. You're saying that he gypped you out of money. That you sued this man for unjust, what I say, unjust enrichment, breach of fiduciary duty, and negligence. Where's your proof at? You have the burden of proof. Where is your proof at? Y'all let me know what y'all think about this in the comments below. Don't forget to like, share, and subscribe. Until then, you all have a blessed night, and I'm gone. Bye.